what he's going to do today is yell a little bit more at technology companies and at us as lawyers for not holding them more accountable. So I'm going to let you talk in maybe for like half an hour, 35 minutes, something like that, sure. And we'll take questions. Great.
That sounds great. Thank you. It's a pleasure to see you all here. Thank you for coming out today. It's a pleasure to return to Notre Dame. I visited here in 2014 and really enjoyed it. And I'm thrilled to see the programs that are being built around technology, privacy, information. I think it's a critical component of, I think, modern legal education. Of course, I would say that because I'm a privacy professor. But it's good to see, it's good to be back, and it's good to see everyone and how it's developed. Okay, so what do I want to talk about today? Let me begin with a scene that I replay over and over every single year. So I teach information privacy law at Northeastern University, and on the very first day, I walk in and I say, let's define, before we get into the books, before we get into anything else, I say, let's define privacy right now. No prep, no anything. And I have everyone sort of list out their definitions of privacy. And it goes about how you would expect, right? So some people say, well, privacy is secrecy. Some people say privacy is intimacy. Some people went ahead and jumped the gun and read the Warren and Brandeis article. So they say privacy is the right to be let alone. And so we get the sense that privacy is an expansive concept that can mean a lot of different things. And so that's sort of the idea going into it. But it turns out that I started noticing a trend over the last 5 years. And that's that there actually is one particular definition of privacy, conceptualization of privacy, that seem to dominate all the others, right? So we have this idea that privacy is this pluralistic concept and that it can mean lots of different things, but it turns out that there's somewhat of a rough consensus, and that consensus is that privacy is about control, right? Not that control, this kind of control. The ability to determine who does what with your personal information, right? It seems to be accepted as a truism that privacy sort of elides definition, but if you look around at the way people are actually talking about privacy, then at least with respect to the protection of our personal information, then control is the name of the game. Let's look at the evidence. Mark Zuckerberg has long insisted that the way it seeks to protect the privacy of its users is by putting them in control. This is reiterated not just in statements that he's made, but when he testified in front of Congress and multiple times. It also is the sort of marketing pitch that we get from Facebook over and over, which is whenever there's a privacy mistake or some sort of bad thing that happens, they say, we're going to fix our controls and we will do better at putting you in control. Like the word pops up over and over. And if you don't want to read it, just look for the bolded, italicized, and underlined word, control. But it's not just Facebook. All the tech companies seem to conceptualize privacy in terms of control. It is the espoused fundamental ethos that drives this industry with respect to privacy. And the list goes on. Usually this notion of control is often linked to the ways in which systems are engineered and the tools that these technology companies give users to purposely let them determine their own data-related fates, right? It is a defining concept also for the Internet of Things. Did anyone watch the new Amazon product reveal that they had a couple of days ago, where they say we've got, you know, we're hooking up the water bottle and we're hooking up the chair and we're hooking up your dog's leash and we're hooking up, you know, we're going to make Alexa for kids, all of that. They roll it out and then they all say, but don't worry about privacy because you are in control, right? We see it and they use that word over and over. But It turns out it's not just industry that drives the control narrative. In fact, privacy advocacy groups also embrace the concept of privacy as control and that it should be the dominant goal of data protection efforts. One of the most vigilant and active privacy advocacy organizations in the United States, which I'm on the board of, which I must disclose, talks about privacy in terms of control. As a matter of fact, even I, in the past, have talked about privacy in terms of control over information. So I've been in the boat as well. But wait, it's not just industry, nor is it just advocacy groups or academics. It also, where it really counts, is the way in which regulators and lawmakers conceptualize privacy, right? Privacy, particularly in the European Union, has largely been built around this concept of informational self-determination, which cashes out in the language of control. The GDPR, the General Data Protection Regulation, makes it quite explicit in the recitals that privacy is about control of personal information. But it's not just the Europeans. As a matter of fact, the California Consumer Privacy Act also uses the control conceptualization of privacy to drive its efforts, right? It seems to be the one fair data processing principle that everyone can agree on. And the list goes on. In particular, one of the places that I've seen privacy cash out in terms of control has been in the area of design. Control seems to be the dominant goal of privacy by design efforts. And you can see it cash out in the explicit sort of settings that we have here. They say that the regulation enhances end users' control by clarifying the consent, right? Has anyone ever been in Europe or visited a European-based website, and the very first thing you see is the banner ad pop up that says, by the way, this site uses cookies. Do you agree? Right? Like you're going to say, no, I don't agree, right? Everyone clicks I agree, which we can talk about. That's driven primarily by the e-privacy directive, which will soon morph into the e-privacy regulation. There also is embedded in the concept of the general data protection in Europe, this notion of privacy by default and by design. The idea being that all the buttons and switches that are built should be set to privacy protective defaults so that people have choice and that privacy should be built in from the very beginning. But if you look at the language surrounding what privacy by design should look like, because it's a pretty broad and relatively undefined concept, it almost always defines or conceptualizes privacy in terms of control over personal information. At every turn, almost, it seems to be like that. But it's not just the European regulators again. The Federal Trade Commission has embraced this notion of privacy as control over our personal information, and it's all about giving choices, right? What's more enabling than us having lots of choices? And so the FTC, being a consumer protection agency, also in charge of competition authority, wants to give us all choices, right? We got to empower me with choices so that we can get a functioning market here. Even the pioneer of the concept of privacy by design has embraced it in terms of control. So there's one point that I hope you take away from this talk today, or at least the one argument that I want to make today is actually very simple. I have come to believe that control is the wrong goal for not only privacy by design, but for all privacy and data protection regimes in general. The idealization of control in modern data protection regimes ends up actually adverse to safe and sustainable data practices. Too much zeal for control risks deluding people about the potential efficacy for protection initiatives. If we are not careful about the goals for and values to be reflected in the design of information technologies, then I think we risk building an entire data protection empire at the crumbling edifice of control. I'd also like to make 2 more points to build this out a little bit more. The one, control is a compromised concept for personal data and design. And instead, I would like to offer up different values and different ways to conceptualize privacy that I think better reflects the goal of why we want privacy in the first place and why it is valuable to people and society as a whole. All right. So first things first, control is a compromised concept for personal data. Now, at this point, you might be saying, well, sure, if control is conditional or vague or uninformed or contingent upon some sort of action, well, then of course it's no good, right? If you're just cherry picking sort of bad examples, then of course, then that control doesn't seem good. But and this may be, I've had conversations with people in industry and with regulators and lawmakers. They say our industry or our framework or our goal is actually different. We advocate for real control, not that fake control that you get. I want to argue today that I think that kind of idealized control is impossible in mediated environments. I think it's a pipe dream, and I'll explain why. Control is, for one, illusory. It's a shell game. That's because the control that we are given in mediated environments is structured or engineered by design, right? I mean, technology companies cannot help but to engineer particular results. That is the very nature of the design of information technologies. And so when it comes to control, design is everything. The realities of technology at scale mean that the services that we use must be necessarily built in ways that constrain our choices, right? Imagine a world where every user got to dictate their own terms in an open text box instead of a boilerplate terms of use. Companies would never be able to get off the ground, right? Person A, my terms of use are you don't get to look at any of my stuff and I get all the free things, right? You could imagine sort of that. My terms of use is if you sell my data, you have to mail me a puppy, right? And you can imagine, like, so of course that's ridiculous to think about. So companies have to constrain choices. And so instead we get boilerplate terms of use, we get switches to activate and deactivate and other settings to fiddle with. But our mediated perception of control obscures the fact that design funnels our behavior. People can only click on the options that are provided to them, and we often miss out what the other potential options are. We do this sort of thing to our kids all the time, right? So I've got an 11-year-old and a 7-year-old, and they would want candy every single night for dinner. That is their true choice, right? So instead of saying, well, we could have candy or we could have broccoli, I say, you could have pizza, or we could have Mexican food tonight, right? Both of them at least relatively better than candy, right? And so they get to choose between the two options, and I'm really, frankly, okay with either one they pick, right? I've engineered a choice system where I'm good regardless of the decision it makes, but they get denied candy. We do this all the time, and so do tech companies when they arrange a list of choices, right? Design also nudges us by sending signals and making tasks easier or harder, and it encourages us to act in predictable ways. Companies deploy dark patterns. This is a term coined by UX designer Harry Brignall that are built to exploit our tendencies to prefer shiny and colorful buttons and ignore the dull gray ones, right? Or shame us into feeling bad about withholding our data or declining options or simply making exercising control possible but costly through things like forced work and subtle misdirection and incentive tethering. So how many people have gotten this pop-up ad on their computer, right, if you use a Mac, and if you notice what's missing here on this button? Now we get to do audience participation. Decline. Can't decline it. You're either installing or you get more information about the thing that you're going to install, right? And it turns out that if you click enough, you can finally just get the App Store to close. But if you have a slow computer like I have, like even pulling up the Mac App Store, it's like, oh, God, now I'm going to have to wait a few minutes for it to boot up and close it down, and my RAM gets all messed up, and I hate it. Okay. Here's an example of what Harry Brignall calls confirm shaming on the Dark Patterns website, right? Now it seems humorous, right? So A, we already have our tendency for shiny objects being exploited here, right? You can see the grayscale that sort of almost blends into the background, or you can see the shiny blue objects. And also, if you want to decline, then you literally have to click the button that says, no, I prefer to bleed to death, right? Now it seems humorous, right? Ha ha ha, no, I prefer to bleed to death. But the way in which nudging works is they're not harmful sort of one instance at a time, but the collective weight of all that pressure can crush us, right? And so can you imagine, no, I'm a loser. No, I prefer to get cut. No, I prefer to, bleed out on the street. No, I prefer to have no friends. No, I prefer to have my mother be disappointed in me, right? Can you imagine sort of if we allow that to be at work at scale, what sort of effect that has on our decision-making ability? Sometimes we get wheedled into oversharing simply through the design of online services. Not only is sharing meant to make us feel good, right? It makes us feel good, like keeping a streak going in Snapchat, or nudges us into share old posts, like this happened 5 years ago, you should share it again, or congratulate others on Facebook. But the design of information technologies is such that they make sharing so damn easy, right? All we have to do is barely move our fingers and we broadcast our information to the world. And so the key is to keep the data spigot flowing in order to get people to want to say yes, right? And to require the least amount of effort for them to impulsively do so. Desire has a powerful tendency to dampen skepticism. And if we want it bad enough, we can rationalize almost any sharing decision. Now, of course, we can create rules to protect against this, but the essence of design is to nudge. Of course, these choices are not always harmful of us. Many of them might be quite useful, but asking companies to engineer user control paves the way for abuse and self-dealing at the margins. And at scale, these margins matter. Even among those acting in good faith, we are left with the problem of relying upon the notion of control and choice to do more work for us than it is capable of doing. We risk looking around at the robust new frameworks for data protection like the CCPA and the GDPR and the rules built to encourage meaningful control over personal information, patting ourselves on the back and saying, mission accomplished, when this isn't true. It wasn't even the right mission. The second reason that control is a compromised goal for design is that it is overwhelming at scale. So not only is it illusory, but it's overwhelming. Control over information is very attractive in isolation. I can see why it's taken off as a narrative, right? Who doesn't want more control over the things that we do in life? It's an incredibly American thing to be like, I get to make the decisions around here. I call the shots, right? And so of course we want that. But with that power, right, with that enablement, actually comes, in often legal terms, a practical obligation. If you do not exercise the control, then you are at risk. Companies can take your inaction as acquiescence. The problem with thinking about privacy as control is that if we are given our wish for more privacy, we are given so much control that we choke on it. Some recent strides in design rules, such as the GDPR's progressive data protection by design and default mandate, have mitigated some of the harm that comes from overwhelming users with choices. However, even if the default works, demands are still being constantly and consistently made for us to relent. Anyone that has turned off notifications on their phone for apps like Facebook's Messenger can attest to the relentless, grinding requests for the user to turn on notifications almost every single time the app is opened. Many can relate to the experience of a child asking for candy over and over and over and over until you say, fine, you can have candy for dinner, just stop asking me, right? Because we have other things to do with our day. Willpower can feel finite, vulnerable, and subjective, and systems are designed to deplete and erode our willpower. Once our willpower and ability to make choices has been compromised, the control that we have been given is meaningless. Even if industry figures out the Platonic ideal of how a company can give users data and data subjects control, it would not solve what I call our bandwidth dilemma. People only have 24 hours in a day. Even if one company or all companies perfected a control interface, people that use computers every day would still be faced with the barrage of decisions because they use multiple apps and services. Control will not change the fact that the data ecosystem is vast. The modern data ecosystem is mind-bogglingly complex, with many different kinds of information collected in many different ways, stored in many different places, processed for many different functions, and shared with many different parties. I try to understand ad tech. I was just talking with Professor Woodrow about this earlier, a little while back. I do this for a living, and I still have no idea how it works, right? Like I dig into it, and I look at it, and I go, yeah, fitting, okay, and it's like, it happens sort of so quickly and in such a complex way. It's difficult for me to sort of conceptualize every time I try to make a discrete decision about how is my data going to flow in any one particular given way. But let's say that we toss antitrust law out the window and we let every single company merge into one sort of big Goo-Gapazon buckle, right? And it's just one big company for every platform, and it's the circle, and we only need one for the rest of our lives. Maybe then we could have control. But what that doesn't solve is the inherent tension between presenting risk in a sufficiently nuanced way to describe the complexities of the data ecosystem, which gets us, if we do that, what does it get us? Should be obvious. Let's say I want to give you a full list of all the risks and the very complex ways in which information goes through a data ecosystem. What would you do if you were a lawyer? You would draft up, there were only a legally binding way that I could present risks and then make someone affirmatively assent to those risks. Still nothing? Contracts. Specifically privacy policies, boilerplate terms of use, which nobody reads and no one should be expected to read, right? Because it's literally the only thing you would do. You would like wake up in the morning, pour a cup of coffee, be like, all right, got to get busy reading these terms of use, right? So, okay, we don't want to go the way where we actually fully disclose the risks, right? So what do? We abstract it, right? We abstract it away. We say there are some significant risks to using this. Okay, well that's too vague, right? What could happen to me? Some stuff. What kinds of stuff? They might share your data. With who? Well, a lot of people actually. And now every single time we answer that question, we get closer and closer to the untenable goal of back into privacy policies and terms of use, right? So there's this almost unsolvable tension between abstracting away risks and being so specific about them that humans don't have the resources to actually read them and understand them. So it's also overwhelming when you look at the buttons we get. Of course, what is this? It's what? It's a toggle button, right? It's an on-off button. Green means on, gray means off. And so maybe you're thinking, come on, this is how you have control and it works pretty great. Can I collect your geolocation information? Can I not collect your geolocation information? I get to say yes, I get to say no, right? I just opened the Delta app when I was flying here and a notification popped up. Could we collect your data location, but only while you're actually using the app? Okay, sure, yes. Okay, they asked permission, I gave it, so we should be good, right? Except it never works like that, because it's never in isolation. Instead, we say, okay, well, I got a lot of buttons here because privacy is complex and we got a lot of stuff going on. Right, so compass calibration, on my iPad, okay, we look at all these things. We say, okay, I've taken a few minutes. I think I figured it out, right? I think I have exerted control. My privacy is respected. Companies have acted ethically. We're all good. Except then we say, oh, man, got a lot of work to do here, right? That was just for one app. All right, so control is illusory. Control is overwhelming. The third reason that control is a compromised concept and a way to think about privacy is that it is myopic. When privacy is thought of in individualistic, transactional terms, people's privacy is always being negotiated against what others value. Control should be tempered against other values because no one privacy ideology should reign in a diverse society where other people's autonomy also matters. Because notions of individual control simply don't fit well with privacy as a collective value. What makes us think that the collective result of atomized decisions will be best for privacy anyway? And so scholars have noted that there's a large body of research that shows that people's privacy preferences are uncertain, they are contextually dependent, and they are malleable. The availability of knowledge does not necessarily translate into meaningfully informed decisions. Lawmakers often favor mandated disclosures like the warnings that we give on cigarette boxes because they are cheap and they counterbalance information disparities, which is one of the key sort of things we worry about with consumer protection law. But in reality, companies often know much more than consumers about the wisdom of a decision, which is true. In context, users are being asked to consider the privacy implications of each and every post that they create. But this is an impossibly complex calculation to make about future risks and consequences, right? The harm that often comes from privacy isn't approximate, right? So when we make decisions about even things like surgery, informed consent, the harm typically is proximate. If someone messes up when you go under surgery, you will probably know about it and it will probably be on your body, right? That's not the way it works with privacy. Once the information is gone, it sort of floats downstream, and the harm could occur 1,000 miles away or 20 years into the future because information is stored and smart hackers don't exploit information immediately, right? Or it gets merged into something else, or it gets used back to you to fish, right? So it's attenuated. And so there are lots of difficult things to pull out. And then another problem with control is that it leaves us wanting a firmer moral anchor. Control presumptively gives people's choices, and it presumptively serves autonomy, but idealizing control leaves designers and data subjects without much of a sense of the values that are actually at stake or to be preserved by the system's purpose or design. This lack of an ethical mooring encourages what I think is sort of ideological drift and abuse. When control is our North Star, company leaders and policymakers aren't given much to work with when they're tasked with improvement, right? In the absence of more articulate values, CEO and lawmakers say, okay, well, we did a bad thing. What must be needed is more control. And so if something goes wrong, well, then we must not have had enough control. And the answer to the problem is to just chuck a bunch of more control in it, right? Which, of course, only overburdens the user and makes the problem even worse. So it's not clear to me that more control and choices would help us. Maybe what people need are fewer, better choices driven by moral values. But it's hard to rate which choices are good without a more concrete theory of what we're trying to protect against. This is where additional values, such as trust, autonomy, and obscurity become more important. They give us a roadmap for how to allocate the precious and finite resource of control. We need an approach that incorporates multiple values and is capable of recognizing privacy as a social good. All right, so that's why I think control is a compromised concept. The second point that I want to make, and I'll just make it briefly, is we seem to be using control as a proxy. So when control is expressed as choice in a way that undercuts its own mission, people lack sort of a baseline. They lack a fundamental level of protection, and they are able to choose something that actually makes them worse off. What is needed is a baseline protection that protects people no matter what they choose, right? What we have now is a system that allows companies to offload the risks of data onto the data subject. Justifying control measures on privacy grounds sometimes feels like it requires so much justification, so much stretching and bending and tying ourselves into knots that it feels like it's merely serving as a proxy for some other protection that's just out of our reach. Control feels intuitively right, and it has selling power, so we use it. But what is the result that policymakers, industry advocates, and data subjects are really hoping for? Surely it's not control for control's sake. Control ostensibly serves autonomy, but mediated environments involving personal data, idealizing control actually seems corrosive to that autonomy. Is control valuable because people have such different privacy preferences? Or does it just appear that way because personal data risks are virtually impossible for people to assess? I get into a lot of discussions about this sometimes where they say, well, people have lots of different privacy choices, so we have to reflect those privacy opinions. But one of the pushbacks I have is maybe those actually don't reflect true privacy divergences, but rather different risk assessments. Some people are good at assessing risk, maybe, and some people aren't, or they don't have the information to properly assess risk. And so if data processing is so dangerous that it requires formal permission, I agree. And such meaningful control, consent, and choice can only exist in these elusive and demanding and bounded environments, such as what the GDPR requires, saying consent must be freely given, specific, informed, retractable, and unambiguous. If it can only exist in those very specific circumstances, why are we allowing controllers to proceed in the first place? Isn't it just a contorted and indirect way to pressure companies to lay off risky data practices? And if so, why don't we dispense with the pretense of demanding a form of control that seems destined to misdirect industry efforts towards formalistic compliance without a meaningful change in controller or processor behavior? Okay, so this leads me to where I think what we should be focusing on. So designers should focus more on relationships. Right? The relationships that people have with each other, and by virtue of those relationships, the duties that are owed to protect people's privacy, right? Or for design, we focus on transaction costs. How easy or hard does this design choice make a particular transaction? And how does that affect people's privacy interests and what they're likely to do? And the three values that I recommend, and I talk a little bit more about this in my book, are the values of trust, obscurity, and autonomy. We can talk about this a little bit more in the Q&A, but trust, I say, is the willingness to make yourself vulnerable to the actions of another. And it's the glue that holds society together. Nothing would exist good in this world without the ability to trust each other. And a lot of the people and companies that we worry about in the modern privacy ecosystem are people that we have direct relationships with. You all have direct relationships with Google if you have a Gmail account. You have direct relationships with Amazon if you have an Amazon account, and so on. This is an opportunity to think about creating trustworthy rules within information relationships rather than allowing those companies to offload risk onto users through consent regimes. And we can talk about what trust makes up. Or this concept of obscurity, the idea that when information is hard to find or understand, it is to a relative degree safe, right? And obscurity is something that we value all the time, but we don't talk about it in those terms, right? So many of you say, well, there's no privacy in public, right? This is the sort of, it's axiomatic in lots of privacy law cases that come out. But then I ask the question, okay, well, can I follow you in public? Or even better, can I deploy a drone that is like attached, that uses facial recognition that follows your face, but it only follows you in public? Right? So in other words, if I were to walk out now and I were to go across the street to Roars, the drone would follow me, but then it would just park itself right outside of Roars, right? And it would wait for me to come out, and then I would come out and I'd walk to the next place and it would just follow me. And throughout the day it would follow me, and they would just sit right outside my house in the evenings or my hotel room. And it did that for 6 months. Would we feel like our privacy was being invaded, like we were always being watched? I think the answer is probably yes. But didn't we just say that there's no privacy in public? And isn't that the only place that the drone is watching? And the answer to this riddle, I think, is thinking about privacy not in terms of mere accessibility, right? Theoretical accessibility, but rather in terms of a risk calculus that we all use, right? All of you, I'm just going to go ahead and say it, have probably picked your nose in public, right? You can admit it, it's safe. I've done it, right? Probably wasn't recorded, probably isn't your Facebook profile picture, right? But you've done it. You probably took a risk calculus that no one was looking, probably in your car when you were driving, right? It's usually when we do it. That's in public, people can see it, but the odds are pretty low, right? You may have walked past a window in your underwear, but you know, for a split second. Odds of people seeing you, quite low. This is obscurity, and it's something that we value every day, and it's something that gets eroded by design decisions all the time in a way that we can't meaningfully articulate, right? Because we think about privacy in terms of control or secrecy. But I say we should embrace the concept of obscurity, privacy as obscurity as well. It's one of the many different ways to think about it, right? Or possibly protection from abuse. So one of the really interesting things I try to get into is ways in which personal information or our own limitations are leveraged against us to make choices. Right? Have you ever been faced with like a double or triple negative, right? I don't not disagree to giving you my personal information, right? And you're like, well, what did I actually just agree to? It may be technically true, not deceitful, but yet abusive in a way because the creator of that question ostensibly knows how difficult it is to answer, right? And then there are some dangerous technologies that we should outright avoid. This is a spy camera. All right, so I'm going to wrap up real quickly, and then we can get to Q&A. Lawmakers have more direct options than simply embracing the easy solution, which is a control regime, right? Just get permission. Even the bills that are coming out now, so we've got bills in California, we've got bills in New York, everything except, with a notable exception of one bill introduced in New York, they all rely upon the concept of consent and control because it's easy, because it's established, because we've done it. But there are other options. Prohibit collection outright, mandate data deletion, get serious with purpose limitations and legitimate interest requirements. Change the nature of the relationship between users and companies that are entrusted with our personal data to one that is fiduciary-like in nature. Mandate non-delegable duties of care and loyalty and honesty and discretion. Make rules to ensure that companies cannot unreasonably favor their own interest at the expense of our own. The case against privacy as control is an appeal to more substantive and privacy-relevant values. By expanding the notion of privacy beyond control, lawmakers and industry would be free to create rules and practices that ensure that designers, data processors, and controllers are trustworthy regardless of the control that we are given and how we exercise it. All right, so now I can go Q&A. Thank you.
An exception to all states except for New York. What did New York do differently?
New York proposed a fiduciary model. So New York actually did one of the things that I suggested, which is it said if you have a relationship where you invite the trust of data subjects, then you owe them particular duties. And the way in which they expressed it, now I actually don't know if the full fiduciary model is workable because A, that model has a lot of baggage within its own sort of section of corporate law, and also I'm not ready to call every single person that collects personal information a full fiduciary. But you could sort of think about ways to sort of half measure, like that's why I said fiduciary-like, which is, you know, a duty of reasonable care, and even better, a duty of reasonable loyalty, right? So in other words, you can engage in self-dealing, but not unreasonable self-dealing. Now, of course, as anyone that teaches torts, as Professor McKenna will attest to, when you slap the word reasonableness on there, the next question is obviously, well, what does that mean, right? Which we don't know. I mean, who knows? But negligence started out that way too, and you know, now we have a slightly better sense of it anyway. And that's actually one of the virtues, I think, of it. So, but it didn't pass. I don't think, or maybe it's stalled. I have to check the update on that. But most of the state laws that we're seeing now get introduced actually are following California, the California Consumer Privacy Act, which is the second time California has had a really influential impact in privacy law because they also established the nation's first data breach law in the early 2000s, the data breach notification. And then all the other states looked around and was like, that's a great idea. We should also enact one of those. And now all 50 states have data breach notification laws. Many of them, while they diverge slightly from California, are based on the sort of California model. And one of the reasons that I feel like this is an urgent topic is because California is now, as of yesterday, rolling out another initiative, right, to try to leverage the ballot process, that the sort of unique process that they have to get legislation passed there. And it's consent-based, it's control-based, right?
You talk about nudges and the overwhelming choices. Sounds like there's a lot of parallels between your research and behavioral economics. Is this intentional, and are there any big divergences between this field and behavioral economics?
No, so I draw heavily on the field of behavioral economics for some of the anecdotes particularly. So there are a couple of researchers that have done an extensive look into the sort of role of nudges. Alessandro Acquisti, Leslie Johns, and some of the others out of Carnegie Mellon are Harvard. A lot of the business school professors are focusing on nudges, maybe for the opposite reason, because nudges can be really effective. They're like, this is a great way. Or at least industry seems to be really attracted to the idea of nudges. As a matter of fact, has anyone here read the book Nudges by Cass Sunstein and Richard Taylor? I mean, so that's actually presented like nudges are great. Like nudges can be good. They can help you save for retirement. They can help you, make decisions. But it's been, to me, it's sort of been seen as like a cookbook for mischief. But yeah, so I think in psychology generally, right? So decision making, the way in which people make decisions generally, I think is relevant. One of the key problems with thinking about privacy in terms of control and the way it's been reflected in lawmaking is that it almost is agnostic to the way that people actually make decisions, right? It sort of looks and says, well, did you have the choice? You could have said no instead of I agree, so the fault's on you. And it also has parallels to like boilerplate contract law generally.
So with how much privacy has been in the news in the last couple of years, a lot of companies have started to market their own privacy settings.
Yeah.
Can you tell us how much do you think the market will sort out a lot of the privacy issues that we feel versus what regulations will solve?
So I think the market has a really important role to play in this. One of the best examples, someone asked me, like, because I was critical of a lot of tech companies, someone was like, all right, smart guy, is anyone doing a good job? And one of the examples that I typically give is the search engine DuckDuckGo. DuckDuckGo has been really upfront about making pretty bold promises about how they protect your privacy, and they invite sort of scrutiny. They're like, you don't think, do you think we're lying? Check it out. And they tend to sort of want to back it up. And so my hope was that that would be able to create some genuine competition on privacy. And we're seeing a little bit of movement in that regard. So has anyone seen Tim Cook from Apple basically sort of like throw massive amounts of shade all over Google and like, take out a huge ad against Google? And so, I think that's actually promising in a way to, I think you have to have, in the very least, the market is important because you've got to have industry buy-in for this in the first place. Otherwise, I think a lot of the rules that we enact risk basically formalistic compliance without actually following the rule. And so there's got to be some sort of combination. But I will tell you that there's an area in which the market, I think, is not going to solve it, and that's in the area of facial recognition technology, where the tech companies, even tech companies that are skeptical of facial recognition technologies, are feeling financial pressure to get into the game and exploit it to its maximum potential, because companies like Amazon are going full speed ahead, right? And just sort of, punching the gun. And so my fear is that you're going to have regulation there, because the competition to sort of develop that technology there's a lot of incentive, a lot of business incentives to develop that technology.
Well, I'm curious if you can talk about GDPR and other sorts of regulation and how it actually makes it easier for incumbents to compete relative to startups. Because, there's always this risk that the more you have a lot of regulatory overlay,
right,
the big companies can easily comply, and the young, energetic startups that have 3 people in the garage have a harder time making all these compliance issues. I know a lot of people said GDPR just makes it easier, even though they weren't intending to, for sure. Makes it easier for the large incumbents to comply, and makes it harder for the young to
Right. Yeah. So I've seen that argument put forth several different ways, and certainly I think you see, if you sort of survey the field and see who is sort of ready for GDPR to hit, of course the platforms were pretty ready, and were really good at responding to it because they could afford to have a team of 40 lawyers that did nothing but GDPR sort of all the time. I will say that one of the things that's been interesting to watch in the wake of this, so it is harder for smaller companies that lack resources to have the same staffing, but there's a sort of umbrella effect where the platforms get to sort of test the boundaries, and then the younger companies get to sort of benefit from the wisdom of the companies that want to push a little harder. But also, one of the interesting things that's popped up now is a sort of cottage industry of privacy professionals that exist almost solely to help small businesses. or can offer their services at reduced rates. Now, does it mean that maybe companies, regardless of size, aren't able to roll out products more quickly, right, and to meet demand? Possibly. And Europe has been, I mean, Europe has had a really interesting extraterritorial effect worldwide on privacy law. So there's a really good article called "Privacy the EU Way," written by Paul Schwartz, where he looks at the ways in which Europe has basically exported its privacy model to the whole world, except, I guess, basically the United States and China are sort of the two major, outliers. But I'd like to see some of the evidence of that. I mean, it is possible that there are costs sort of imposed.
So you talked about facial recognition a couple times, and you talked in this talk about data privacy. And so I'm just curious when you believe that my image becomes data.
Well, I mean, I guess technically your image by definition is data, right? So if it's stored in sort of ones and zeros, right, in picture format, then it all of a sudden is data, right? Or when we talk about biometrics, the way in which it actually works is a face print is created, right? So in other words, facial recognition technology doesn't necessarily recognize full faces. Rather, it recognizes a series of measurements with respect to, for example, how far away your eyes are from your nose, from your lips, from your forehead, right? So recently, facial recognition technology, I read, got foiled by someone getting a nose job, right? Because there are very specific measurements that recognize faces. And of course, all of those are just data points, right? Personal data points attributable to you. I mean, one of the interesting questions that privacy law has been wrestling with a long time is, at what point is data pseudonymized or anonymized, right? Or what I like to use, de-identified. And it sort of exists along a spectrum. It used to be, we thought that if you took out someone's name, then it was anonymous. And then some really smart computer scientists were able to prove, like, no, we can totally figure out who that is. There was a really obvious, a very public example of LaTanya Sweeney, who's now a professor at Harvard, but at the time was a doctoral student at CMU, who got hospital records that had been anonymized, and was able to cross-reference those with some public records and say, that person right there, this patient number 10357, that was Governor William Weld, and it was, and it was like, ooh, maybe we should be more rigorous about de-identification techniques. But my theory on all of this is that perfect anonymization is possible, but that doesn't mean we should give up the endeavor. That it exists along a risk spectrum. So I'm a torts professor, so life is risk, right? And some risk is acceptable and some risk is not. And maybe we can sort of de-identify information good enough, right? And that's where and I'm happy to talk about that debate later. That's a whole thing.
So I agree with everything you said here. I read the book and agree with everything in that. But I'm wondering if you dig just a little bit below these issues. Because the root of the genesis of all these issues is the fact that most of the time when we talk about tech, we're not talking about a relationship between the vendor and the customer. We're talking about a relationship between the platform and the user.
Right.
And so many of these privacy issues are, the illusion of control. It often seems to be an attempt to sort of camouflage what is almost an adversarial kind of relationship. So how do we address that? Are we really going to be able to directly approach values and security and have this frank conversation in the context of what remains a kind of uneven relationship? Absolutely.
So I think that this is where relationships of trust come in. So you're right that without some sort of recognition, the sort of natural state between users and platforms is one of vulnerability on the part of the users. There's a massive information disparity and there's a massive power differential, right? So platforms get to build the environment within which we operate, right? So they get to pull all the levers. And there's a fair amount of scholarship now sort of hypothesizing this is exactly what relationships of trust were built for. Right? In other words, that you shouldn't be able to take advantage of your power differential because it is so extreme. Right? That this, in other words, is not a party like in contract law where we make a presumption that we're operating at arm's length. Right? That this is, even if it's take it or leave it. Right? This sort of classical style of bargaining is, You didn't have to take the terms. You didn't have to use Google. You know, the DuckDuckGo is sitting there waiting for you on the other side. And maybe that's true in some cases. But collectively, I think it's really disingenuous to say that if someone doesn't like the terms, they can just get off the internet, right? I mean, I don't think that's a workable sort of, if that is the sort of natural, you know, endpoint that we're talking about here, I don't think that should be, right? Just as a normative matter, I think that's a bad deal. And so rather make these relationships of trust, make these impose reasonable duties of care, reasonable duties of loyalty. It won't solve the problem. There's a really good critique of the fiduciary proposal for privacy out there that says that, you know, if you're really serious about limiting corporate power, which is what it's about, you don't look at privacy law, you look to competition law, right? And that's where, you know, but that was also written by an antitrust scholar. And so when you're Hamill, everything looks like a nail. I'm a tort scholar, so everything is like a reasonableness test, right? So, but it's a good point, and it's one that, you know, and then my answer to a lot of this is like, why not both, right? Why can't we have one and the other, right? And then there are questions of, well, do you want to use up political capital on one approach versus another? You know, do we have enough sort of realistically speaking, political capital to enforce both through, or maybe we only have enough for one good push, right? Or something like that. So we could talk about that.
So I want you to put a little more meat on the bones of trust.
Okay.
Right? Because what Facebook actually does say is the reason you can trust us is because we give you control, right?
Right,
so
exactly.
Trust is also an intermediate value, right? Which is basically like what you can do is create the conditions for a trusting relationship, but what's the content of the relationship, right? So what does a reasonable duty of care or loyalty look like? What expectations are we actually putting on their behavior that we can sort of fill in? Because otherwise what you wind up is it backslides into, oh, well, we want the conditions for trust, and that just means transparency and control
Right.
and all those kind of things, right? The reason why I can trust you is because we know each other, right? We have a long-standing relationship, so that's all I need to do is just create the conditions where Facebook is disclosed enough to you that now you know exactly what's happening, right? If you want like substantive requirements, I guess I want a little more meat on the bone.
Absolutely, I love it, and we'll do so. This is a really good critique of the trust model, which is that it can be easily hijacked, right? In other words, like sort of like privacy design sometimes, like we do privacy by design, or even AI ethics, right? Like everyone sort of grabs that label, slaps it on, they get a little halo effect, right? And then it's like, hey, we're doing trust, when really there's just this business as usual, right? So you would need a sort of a rigorous enforcement component to this. So I can think of no better one than putting a private cause of action in, and then we can sort of get to the bottom of it. There are costs to that, of course, and politically it may not be the way to do it, but it's a way, if we're doing the sort of common law method, to get down quickly to what is reasonable in certain contexts and what isn't, just through sheer numbers. I also would sort of favor enabling not necessarily the full weight of the US torts court system, but also thinking about data subject rights as a regulatory mechanism that allows, and so under the GDPR in Europe, data subjects have what's known as data subject rights, right? So you can request deletion of your information, you can do stop processing requests, you can request that data portability, like give me the data so I can take it somewhere else. You can request transparency, show me all the data you have on me, let me correct the misinformation that you think you know about me, right, but is actually wrong. We could embrace a system like that, right? And in fact, the CCPA is an attempt to do that. So that's the regulatory arm. But now let me answer your actual question. So I actually conceive of trust, the model for trust or fiduciary has been thrown out several different ways. I conceive of trust as having 4 parts. One is discretion. Oh, that didn't work. One is discretion. One is honesty. One is protection. And the final one, and the most important one, is loyalty, which I'm working on an essay with my co-author, Neil Richards, on that right now. So discretion is a little bit like confidentiality, but a little more permissive, which allows us to apply it more broadly, right? And then we would have to subject it to a reasonable test. But the idea is you are discreet with people's information, which means if you do share it, the obligation is on you for reasonable de-identification, right? So non-risky de-identification, or you share certain things, but not in a way that would violate, we could use maybe people's expectations about what would be shared and what wouldn't be, right? Or what would violate a standard person's a reasonable person's expectation of discretion in a relationship. And we'd have to that's a factual question to determine what we do, but we could maybe try to answer it. Honesty is the really interesting one, because honesty seems at first like notice and choice, right? Which is just you dump it in the privacy policy. But the way I articulate honesty is akin to what Paul Ohm has given. He said companies should be forthright. And the difference between transparency and forthrightness or honesty is an affirmative obligation to reveal the things that you would rather not users know. Right? So in other words, it's not telling you all the risks, it's telling you specifically the worst risk that you likely know would matter the most to people. Right? So again, it's about putting an affirmative obligation on companies rather than a sort of formalistic checklist of things that you have to disclose. And it requires a sort of calculus. Protection is sort of data security. So it's the standard. That's actually the easiest one to do, which is encrypt the information, don't store passwords in clear text, keep it from outside companies, right? Do your due diligence when you're sharing information, which also could sort of fall under discretion. And then the final one is loyalty, which I'm actually going to go ahead and admit I haven't fully built out because it's the hardest one. And I'm working on that right now. But the idea would be not an absolute bar on self-dealing, which is what I guess traditional fiduciary law tends to rely upon, but rather a duty not to engage in unreasonable self-dealing at the expense of someone else, which requires you then to articulate what are the interests involved and what do we constitute going too far, which are admittedly very hard questions, but because I'm a torts professor, I'm confident that standards can eventually, the needle of standards can be pushed in the direction of rules over time. Does that help?
So there was a piece in the New York Times this week, and I have to admit that I didn't read it very closely, but it suggested that some recent cases have rolled back the EU standards in terms of being able to delete information and things. And I just wondering if you could speak to that. I mean, they characterized it as a huge shift away from that, protection, and I was just curious if you're agreeing with that.
So this is one of the areas where I go to conferences in Brussels and I just sit and listen to try to understand it, because the GDPR is actually, I don't know if this is all European law or if it was just the GDPR, but it seems to me that there was a lot of like, get the rules out first and we'll figure out what it means, like as it comes time to apply it. And the rules around data deletion and also data portability, we're still trying to figure out what that means, because it's really hard, because one of the questions that we had is like, well, do we delete even the pseudonymized information? And would that require us to unpseudonymize it, like or re-identify people in order for the purposes of deletion? And then data portability also sort of seems to work like against that in some ways, right? So what actually we're coming to find out, which maybe we knew all along, and this is just part of the process, which is that there are conflicting values even within the GDPR that we're still struggling to square. That being said, I don't sense that the resolve has changed any. So because data protection is a distinct fundamental human right within Europe, even apart from privacy, so that it's actually like two different, distinct rights. That I still get the sense that there's a very firm commitment to it. A lot of it is just sort of trying to figure out sort of how to Tetris block this thing so that all of the rights get cashed out. Did you have a question? Wait, I want to make sure we're on time. What kind of time are we looking at? One more? Okay.
So I want to ask you how you can feel the gap between all the statutes and regulations and the user skills. Because sometimes, the real law is in the relationship between the company and the user. And sometimes the user doesn't know how to use the things and how to protect his or her own property. Yeah,
well, this is a hard part. I mean, this is one of the reasons that I find control a sort of frustrating approach, is that it sort of relies upon the idea that not only do we have a lot of time and ability, but we have a sort of general shared set of knowledge about the way in which, not only in which technology, like what people have on us and what's being collected, but how technology works in the first place, right? So when I give a lot of talks for this book, I got a lot of questions about like, like, how does the internet actually work? Because it seems like magic, right? And in any technology of sufficient complexity, you know, is indistinguishable from magic. And so with that, which is why I favor sort of putting affirmative duties on companies rather than putting, you know, sort of making assumptions about people's abilities to work within technological systems. And one of the answers to that, though, that is really nice is that data subject rights empower users, but in a sort of asynchronous and non-time-bound way. And so consent regimes, sort of, you have to make the decision right then and there, or else you can't proceed. Whereas the data subject rights will always be there for you, right? And you're always able to sort of request deletion. So I feel like that's a way to sort of maybe to ease the pressure on users who might struggle to and reasonably so, to make decisions about this vast ecosystem. Okay, I'm sorry, I think
Now
I'm
you're just gonna rewrite all the rules, right? And so we all have-
Well, so this is also a big critique, which is like, are you proposing that we rewrite the GDPR, which is, of course, maybe not feasible, but the US still has not, we still don't have a federal data privacy law, so there's still hope for us. All right, thank you.